Today, we will try to explore the law on filing a written statement. As we know that this law pertaining to filing the written statements in law courts in civil suits has become a confusing law, a confusing zone in the legal field. This is so because there is a separate law which is called the Commercial Codes Act. And in this act, there is section 16, which has been amended, and time frame for filing the written statement is fixed. And accordingly, the insofar as this act is commercial act is concerned, the proviso to Order 8, Rule 1 has also been inserted by the legislature, which very categorically says that if the written statement is not filed within a stipulated period of 120 days, then the right of the defendants shall be forfeited. And further, the legislature has put a note on the discretion of the court that then the court shall not take such untimely written statements on record. So this is precisely the law. What is not understood is by many, including the law courts, that the so far as the pre-amendment law on written statement is concerned, and which is contained in Order 8, Rule 1, that time frame was given for 30 days. And if it is not filed within a period of 30 days, then court is having the discretion to extend this time to maximum 90 days. And if within 90 days the written statement is not filed, then the right was, as usual, closed. But the point which I want to bring in the forefront is that sometimes what happens before filing the written statement, most of the advocates they resort to Order 7, Rule 11. They file applications for rejection of the suit on certain points which they formulate, and they forgot to file the written statements. And because of those applications under Order 7, Rule 11, filing of the written statements is dragged even beyond the 90 days and even 1 year, 2 years. But despite that, courts used to ignore the defendants to file statements. Now, what I want to project here is that so far as the pre-amendment era is concerned, the discretion was not taken up by by the legislature. The courts were having discretion that if sufficient explanation is coming to the courts, then the court would extend the time. But the problem arises when the Commercial Act was amended, particularly section 16 and the schedule thereof, therewith. Then the CPC was amended, and the outer limit was provided 120 days. Now the point arises that whether there are two regimes existing in the civil procedure code, or after the amendment of uh, Commercial Codes Act, there has become a one regime. That is, they replace the 90 days time with 120 days time and made it a final short. Many, in this respect, many uh, interpretations, precedents has come, particularly from the Honorable Supreme Court of India. And the most important of all the judgments is Deshraj judgment, which clearly lays down. And the law has been interpreted by the Supreme Court in this respect. And the court has clearly made the distinction in this. And it has conspicuously said that the there exists two regimes in CPC, in Code of Civil Procedure. One relates to the unamended era, and the second relates to the amended era. That is, the suits which are commercial in nature, that is to be dealt in by the strict law inserted in the CPC, that is 120 days, the outer limit. And thereafter, the court's discretion is taken away, and courts cannot grant extension of time. That is one regime. What the Honorable Supreme Court has said about the second regime is that is the era of unamended CPC. The suits which are not commercial in nature, that is to be dealt by the unamended law, which means the discretions which the courts are using since long time, they will continue to use those discretions and extend time insofar as the suits uh, of non-commercial nature are concerned. But unfortunately, then there has come another judgment also in 2022, which is uh, Bharat Kalra case. In Bharat Kalra case, Supreme Court again clarified the natures of the foods. And it has clearly laid down in that, that the the commercial suits and the non-commercial suits, they are to be dealt differently so far as the Torah fuel procedure is concerned. Uh, what I want to convey is that the discretion of the courts, insofar as it relates to the non-commercial suits, exists even today. And so far as the suits of commercial nature concerned, the courts have no discretion to extend the time in filing the statement. This is what exactly the law is. But we have seen the the courts are not adhering to these judgments, and they have taken it once for all that 120 days stipulated time. They made it applicable to both the natures, the commercial suits and the non-commercial suits, which needs to be revisited by the subordinate law courts who are not adhering to the precedents, ratios laid on by the Honorable Supreme Court. I hope to some extent this will make the things clear. Uh, and the belief that we will try to revisit on this law of filing written statement as it is contained in order 8, Rule 1, uh, then Rule 10, then Section 16 of the Code Act and schedule appended to this Act. Uh, hope this has come here to some extent. It needs discussion. Hope the legal fraternity will irradiate on this point and take it further. Thank you. Thank you very much.